Thank you. Thank you, Ms. Campos, for the bill presentation. And obviously, this is a topic that people have struggled a little bit over. I look at your bill, and I see it as something that simply seeks to assure that the public has a right to participate in the public process. And I'm hearing, in the conversations that we've had, that there are opportunities to perhaps resolve some issues in getting your bill where it needs to go, and I'll be supporting it today, and I'll move the bill.
Thank you.
Okay, we have a motion and a second. We'll go in order. Mr. Gordon.
Good. Thank you, Mr. Chair. Ms. Campos, I will be supporting your bill today, but I would encourage you to work on a couple of areas where I think that the bill could be provide greater clarity. One is as it relates to what are reasonable regulations for a local body to adopt relative to the public testimony. It seems to me that that potentially is as some of the opponents said, perhaps a little bit vague and perhaps leads to some level of subjectivity. I want to make sure that the public has the right to comment. I want them to be able to do that in a timely manner. But I also think that the legislation would be stronger if we were clear about what was really meant by reasonable regulations. And then you answered a question of the chair earlier around clarifying what is null and void, whether it would be the entire agenda or a specific item. I also think, as I read the bill, that could use a little bit more clarification. So I'm hopeful that you'll look at that. I will support the bill to move it forward so we can continue to have these discussions.
Thank you.
Mullen.
Thank you, Mr. Chair. Thank you, Assemblywoman, for the bill. I just want to echo my colleague's sentiments around clarifying. I intend to support the bill today. My question is centered around litigation. I'm no fan of unnecessary litigation and clogging our courts. I heard witness reference the opportunity to avoid litigation, but one of the chief arguments by the opposition is that this will lead to unnecessary litigation. Can witness speak to that issue and what the anticipated real-world effect would be if this moves forward in our court system?
Well, I can definitely, our office can get back to you with a more comprehensive answer and definitely connect you with our attorneys working down in Southern California and who've kind of litigated some of these issues. The opportunity for, in the real world, the opportunity for the entity to cure and correct is something that we think is probably going to happen more often if there's a violation at all. So I think that's.
So let me clarify a few things. In listening to your technical question that you asked, I think what's missing here is that this will not, I'll use Mr. Chair as an example. He is presiding over this body. We would hope that he would give a reasonable time. I think this answers some of the questions. This bill does not dictate on what that reasonable time. If you have 100 people in the audience and your normal procedure is to give somebody 3 minutes to speak, but you as a presiding chair decide that we'll be here till 1 o'clock in the morning, if we give everybody 3 minutes, then you have the ability to determine that. What this bill does is it gives people the assurance that they will be heard, whether it's 3 minutes, 10 minutes, 30 seconds, but that it gives everyone the opportunity. And if the chair decides to pick and choose who can speak, if I was one of the last people and I was exhausted and I wanted to go home and the chair says, well, you have 20 seconds, you can't change the rules in the middle of the process. So I think that and if not, then they would have the ability to because there would be a mechanism within. I'll use the city as an example. Within the city, to be able to go back and say, I did not get my due process to speak on that item, and the clerk or whoever's in charge can decide, we will hear, in my city, it would be the next week. We'll agendize it so that we can hear that item once again. They get their full minute. Doesn't mean that the body has to change how they're going to vote on that. If it's still going forward and the other person's opposed, they can still move forward. But they had their opportunity to voice their opinion and be part of democracy.
I certainly appreciate that spirit.
So I think that's,
Yeah.
but I hear some of your concerns, so I'll go back and tighten up the language.
And I think it's just an issue of clarification and definitional, but.
Right. And I'll go back and clarify that.
Thank you.
Thank you. Mr. Vallejo?
Thank you very much. I'm going to be supportive of this bill. Certainly, the Brown Act is an issue that I care deeply about. In fact, one of the bills in the analysis by Senator Yu, we co-authored that in 2012 together to expand the period of time for aggrieved parties to be able to go and file a claim in court. But as we all know, the public's voice on issues, action items on the agenda are paramount. And there needs to be some guarantee or some way to enforce that voice is going to be taken into account. Usually at a public meeting, you have a period for the public to comment on items not on the agenda and then those that are on the agenda. But there is a void in existing law because currently if the public were to be shut out of an action item, the only relief they got under the bill that Senator Yee and I co-authored was they could get declaratory relief, just saying the city violated the law. They could get an injunctive saying in the future you cannot no longer shut the public out by whatever particular city council or school board or board of supervisors, and you could get court costs and attorney's fees. But the public who lost out on their chance to comment on that action item cannot go back and reopen it as law is right now to provide that public input to their elected officials. That's where the void of law is. And how I see your bill, it's a remedy that parallels already existing remedies
Correct.
in other parts of the Brown Act. If City Council were to fail to post their agenda 72 hours in advance, that's what you're asking in your bill is that exact same remedy, that they would have to go repost that meeting, conduct the meeting for that action to be valid. But you also parallel the cure and correct mechanism. You sent a letter saying, I allege that you did not have an opportunity for the public to comment. It's going to be a very clear, bright line rule. Either they allowed it or they didn't. They could look at their minutes, they could go look back at the video, and all they have to do is post the agenda, hold the hearing, and cure that previous violation. If they do that within 30 days, their action stands as you were just describing. There will be no change, but they have to guarantee that public comment period. And within 30 days, it's a reasonable time. If they don't have no meetings set within 30 days, they could call a special meeting. Correct. So it's very easy to do that and follow the law. I do share the concerns that were raised by some of my colleagues already, narrowing it, just clarifying that it's only for not informational items. As we know on agendas, there's informational items, and then there's action items. So the only thing that you could cure is when there's an action item on official vote taken by a particular body. It should be narrowed that it would apply to those official actions, not informational items. And certainly needing to have flexibility so that a chairman of, or a mayor or a president of a board of supervisors has the flexibility to set reasonable limits in terms of public comment. As you mentioned, a great example happens all the time. There's a controversial issue, 100 people show up. If they have to each get 3 minutes, then you'll be there all night. Sometimes you can scale that back in those situations to a minute so that you could get through your other business of the day. There's even another problem that I confronted, and I think that needs to be fixed also. And it was a meeting that I attended, and I was personally shut out of public comments because in that meeting, I got there maybe about 8 o'clock. The item wasn't heard till 10:30, so I waited 2.5 hours, and I got up I wanted to testify on that bill. The government entity, the chairperson told me, no, public comment for that item should have been done at 5 o'clock when they first started the meeting. So even though the public wasn't on the agenda till the end of the night, and it was 10:30, the public had no way of commenting. So public comment should happen when the item is actually taken up by that body. So because usually you have a staff that present a report, background, recommendations, alternatives to a city council, board of supervisors, and then it's at that moment where the public is able to weigh in. But some local entities are putting the public comment or any public comment periods at the very beginning, even though the issue's not even been discussed or a presentation hasn't even been made. It's just another it's another void that exists in the current law that should be strengthened. And so that when an item comes up, that's when the public comments happen, when the entity is actually considering and about to deliberate on that particular item. So because of that, I'm going to vote for it. It seems that there's a lot of the concerns that were spoken about earlier can be addressed with some fine-tuning of the language, and I heard that you're open to doing that.
I am.
Anyone else? Ms. Melendez?
Thank you, Mr. Chairman. Ms. Campos, we had, our staffs anyway, had a conversation about some of my concerns in this bill, which were already raised by the other committee members. And I agree with what you're trying to do. I think everybody should have their opportunity to speak and have their comments heard, no matter how long it takes, frankly. And I've been on a council where someone from the public was shut down from speaking simply because they didn't like what the person had to say. And that's not right. No matter whether it's criticizing someone or praise, you still have the right to be heard as a citizen. My biggest concern is that we don't clarify in here that it's only that particular issue that is being discussed that would be null and void and not the entire agenda. I understand your intent. I think it's not clear in here.
We will clarify that.
Okay, so that is one of my biggest concerns. So for today, I'm going to hold off until we get to the end and you make all the changes that you feel are necessary before I vote. But I do understand what you're trying to do, and I do agree.
Ms. Walter?
Thank you, Mr. Chair. Just to tag on to all the comments, I understand what you're trying to get at, and having served on the City Council for 14 years, every now and then there was kind of an anomaly that, might happen, never with intent or anything, and, so it is an important issue. Hearing the public out on these issues is critical. The bill, I think, is kind of just in the works. I think there's a lot that can be done with this. My concern is it keeps talking about the cures and the remedies, how we correct it, and it's really, just coming back to another, noticing a hearing, coming back, reopening the public hearing is what I'm understanding to correct anything if it's determined that someone has not gotten their full say. But in so many instances, there's time deadlines, there's all other factors that come into that, including contracts and, all these other legal obligations that cities are under, spending grant money and all these things that may not be the ability to go 30 days or whenever it could be. They could post another agenda and have another hearing. And I know some of the smaller water districts or other smaller districts, like our Planning Commission, may not be videotaping a meeting. Our council did live stream. We were, videotaping everything. So, in that case, how would it be proven? Is the burden on the person to
file? Are you asking, is the burden on the person to file?
Prove, the burden of proof on them to prove because there was no videotape of it. It's kind of like he said, she said kind of a thing. So I have these concerns, and I too will just lay off at this point because I want to see what comes back. I think there's work to be done on it, and I understand what you're trying to get at, so I'd like to see what comes out of it.
And I appreciate your comments. When you're in a public setting, even if there wasn't a video in here, and someone came up to the mic and said, I need to speak on that item, and they weren't heard, and they were cut off by the mayor or the supervisor, I think that there is enough witnesses to know that that particular person was cut off. But the burden is on me to go file to say I did not get my due diligence to be able to speak before that body. And I believe that even if there's not videos, there's minutes that are taken and recorded in a public setting. I served for 10 years as well and saw a lot of things that I was not pleased with and kind of made me feel like we should do better as a body because we're serving the community, and everyone has a right to be able to speak on a project that is going to be built in their neighborhood, whether they're for it or not. And dynamics change on the council. So I understand your concerns, and I'm going to address some of those concerns, and hopefully at some point you will be able to support it.
Okay. Thank you.
Thank you, Ms. Campos. I do appreciate your efforts. Yourself and all of us, the rest of us, we all condemn abuse of power, no doubt in my mind. Some of those concerns I'm hoping will be addressed. We'll see it in writing. Since we can take it here in amendments, they're not in writing. Look forward, and as a reminder, this is going straight to the floor, so that we don't have opportunity to see it till then. Look forward to be supporting it once that those concerns are taken care of or addressed properly with some clarification. With that, your closing remarks, ma'am?
Well, my closing remark would be that once we make these changes, I will make sure that a fresh copy gets delivered to your office so that you can see it before it goes to the floor, and I respectfully ask for your aye vote.
Thank you. With that, Madam Secretary, would you please call the roll?
The motion is due pass. Excuse me. Hashajian. Levine. Alejo. Alejo, aye. Bradford. Gordon. Gordon, aye. Melendez. Mullen. Mullen, aye. Rendon. Rendon, aye. Waldron. 2, 3, 4, 5. Bill's out.
Congratulations, your bill is out.
Thank you.
Thank you. Members, this concludes our business for today. Without objection, we will leave the roll open for 5 minutes for add-ons, after which time this hearing will stand adjourned.